This morning in Legal Logic, we are talking accidents and, yes, athletics. Who is liable when it comes to injuries on the school fields? This morning, we have Brian Kuna of Brian Kuna and Associates here to tell us about the specifics behind school sports. Good morning, Brian.
Good morning, Will.
Nice to see you. I was talking to you before, and I told you, look, this recently happened in my family. Daughter got injured on the soccer field. It's happened more than once. But looking back, there has been multiple injuries from multiple kids. So really, who is responsible when you send your kid out onto one of these fields and maybe the field's in poor condition, maybe the equipment's not that great? What happens?
It's a very difficult area of the law, okay? Traditionally, we had something known as sovereign immunity, where governments, their agents, such as schools, police departments, fire departments, were not liable at all to maintain their school fields, to maintain their school buildings, and everything else. The law has evolved in both Massachusetts, Rhode Island. In fact, every state has laws now that state that you have to be responsible to maintain your premises in a safe condition. However, with regard to schools particularly, okay, we have something known as the public duty doctrine, all right? And it exists both in Massachusetts and in Rhode Island. Massachusetts is codified. It's actually in a law. In Rhode Island, it's more the common law. And what it says is that there is no liability on schools, municipalities, towns, if in fact what they're doing is a maintenance function, such as fields, such as school buildings and so forth. And it provides liability against those particular institutions, unless it comes under some sort of exception, egregious conduct or a special duty. With regard to schools, there is a special duty towards students, okay? Right. However, if the function is a maintenance function, such as a school field, the limit of liability is $100,000, both in Massachusetts and Rhode Island. Right. Unless you can get beyond that, there's no liability, and the most thing you could ever collect from any school district for fields or anything else is $100,000. Secondly, there's another problem. Most parents, where their kids are involved in sports, sign on the dotted line and say, even if the school is negligent, I understand I am relieving them of liability. We've all seen this as parents. We've all signed them, and we say, well, here, sign this. And you say, don't read the darn thing, and there's no liability. Right. Go ahead. Yeah, so there's nothing that... I mean, is there a level that schools and towns have to at least be at? Like, they've got to look at this and go, okay, the fields aren't in that great shape. We need to do something. If somebody gets hurt, there's zero responsibility. There's some exceptions to this public duty. I know it is not an area of the law. It is it's abstruse to use a word. Sure. And one of them is the egregious conduct exception. In other words, if the conduct on the part of the school, they know that that school is that field is run down. They know that there's a problem with the fencing out in the outfield that's broken, or some kid's going to run into it. Right. Under those circumstances, there's no public duty. There is liability. But again, it may only be $100,000. There's one last thing, and it's called the recreational use statute. We got to wrap, but we will put that on our website as well. Okay. All great information. And a lot of parents, you sign on the dotted line, it's kind of all gone. Well, that's it. Yep, thanks so much, Brian, for coming in, and keep your children safe. If you would like more info, like the extra info Brian said, we're going to post it at roadshow.com.